Welcome back, everyone. Sean Stevens here again with Metroplex Mortgage Services and our divorce mortgage planning video quick tip. We previously reviewed how a properly structured equity buyout refinance can help a divorcing homeowner retain the marital home, maximize loan to value ratios, and access available equity without triggering the higher terms associated with a cash out refinance. In today's video, we're taking the next step by breaking down the elements needed for a successful equity buyout, and more importantly, explaining what family law attorneys need to know to help prevent common pitfalls. Whether you're drafting a marital settlement agreement or navigating post-decree compliance, understanding lending requirements is key to protecting your client's ability to refinance and meet the terms of the MSA. Now, before we begin, if you haven't already done so, take advantage of our free divorce lending blueprint for success with the link below. This step-by-step guide is designed to help attorneys and homeowners navigate the refinance process with clarity and confidence. As a starting point, the success of an equity buyout refinance depends on how the agreement is written and when the mortgage strategy is implemented, which means that family law attorneys should consider this early in the process. Even when the intent is clear, small missteps in the settlement language or timing can disqualify the loan or reduce the amount of available equity. Here are key drafting provisions to consider when structuring an equity buyout under conventional loan guidelines. First off, the joint ownership requirement. The subject property must be jointly owned for at least 12 months prior to the funding of the new mortgage. This is routinely met via the property appraiser site. There is an exception to this rule for recent inheritances of the subject property. This is important to attorneys because if one spouse has recently added a title or never held ownership, the refinance may have to be classified as a cash out, resulting in reduced loan to value limits and available equity, along with less favorable mortgage terms. Next, all parties must sign a written agreement that states the terms of the property transfer and the proposed disposition of the proceeds from the refinance transaction. Please look out for vague or incomplete language within the marital settlement agreement, because to qualify for an equity buyout under rate and term refinance guidelines, the marital settlement agreement must clearly state which spouses retain the home and the amount or percentage of equity to be distributed. Now, because lenders rely heavily on MSA language to structure the loan, it is critical to draft these terms clearly and address them independently. If the equity division is unclear, incomplete, or missing, it can delay underwriting or lead to a loan denial altogether. Next, it is important to understand that the borrower cannot receive any loan proceeds. The divorcing homeowner who acquires sole ownership of the property may not receive any of the proceeds from the refinancing. This clearly means that the borrower may not receive any cash out in any form with this transaction. For example, they could not consolidate debt, access emergency cash, pay for attorney fees, or other items. The equity being dispersed is strictly for the departing ex-spouse, which is evidenced by the closing disclosure. Please note, if the divorcing homeowner receives any part of the equity, the loan is disqualified from equity buyout classification and reverts to a cash-out refinance, which results in more restrictive terms and possible refinancing issues. Even the most well-intentioned settlement can derail the financing if title timelines are off, equity distribution doesn't align with loan guidelines, the divorcing homeowner receives funds directly, or the MSA lacks specific lender required terms. This underscores the importance of implementing a proper divorce mortgage plan before the marital settlement agreement is signed. It is important to work with a team that understands both mortgages and divorce. At Metroplex Mortgage Services, our divorce lending practice group works alongside family law attorneys to help draft lender-compliant settlement terms, preserve client eligibility for equity buyouts, maximize equity and available loan options, and provide expert insight on credit qualifying, income analysis, and loan requirements. Whether you're drafting the MSA or troubleshooting post-decree financing, we can help ensure mortgage eligibility aligns with settlement intent. If your client intends to keep the home, early planning makes all the difference. Contact us to review options, assess qualifying limits, and ensure enforceable mortgage compliant terms. And thank you to our valued family law partners. We appreciate your continued referrals and the trust you place in our divorce lending practice group. We're proud to serve as your partner for navigating mortgage-related issues during divorce. On a scheduling note, we're currently coordinating in-office and virtual presentations for Florida family law firms. Each session is customized to address equity buyout refinance planning, purchase options and down payment requirements, credit scores and debt-to-income ratios, and how to structure enforceable mortgage-related provisions. Just contact my office today to reserve your preferred date. As always, I want everyone to make it a great day and look forward to seeing you right here for the next Divorce Mortgage Planning Video Quick Tip.